All right, so you have money, you want to leave it to your kids, maybe a house, maybe money in a retirement account, investment account, something like that. But you're concerned about your kid from creditors, right? So maybe they've gotten into some legal trouble and they've got some judgments against them, and you're afraid that if you leave them the money, the creditors are just going to take all of that money. Or maybe you're just concerned that, hey, if they do get in a lawsuit, I'm afraid that those creditors could come after them, or whatever, gambling debts and anything like that. So you're concerned, hey, I want to leave my kids this money, but I want to make sure that they actually get to enjoy the benefit, and we don't just leave it to them and then it gets taken by by creditors or something like that. So what can you do? One of the things that we see, and this is really dependent on your state, but one of the things that we'll do for clients is set up some sort of trust, a credit protection trust, creditor protection trust, so that the kids, basically, you protect them from themselves. Now, you can't just give them the money, because the kind of the legal saying is the creditor stands in the shoes of the debtor, meaning that if any money is coming to the debtor, the person who owes any money, or in this case your kids or beneficiaries, whoever you're leaving something to, if they're getting any money, the creditor can potentially go after that, right? And so where we see a lot of that is credit card judgments. If you don't pay your credit card bills, eventually, depending on the credit card company and the amounts and everything, they can do what's called garnish your bank account or garnish your wages, where they can actually direct your employer to pay them in order to get paid, or they can put a lien, essentially. It's not really a lien, but put go after your bank account, so that anytime there's money in there, they get it. And that's kind of the same thing here when we're talking about, if you just leave them money, those creditors could potentially go after that. If it's in their own bank account, they could potentially go after that as well. So what we want to do is we want to set up some sort of protection where, for all intents and purposes, your heirs, your beneficiaries, don't have immediate access to the money. Because if they have access to it, again, remember, creditor stands in the shoes of the debtor. If they have access to the money, then then the creditors are able to get it. So we want to set up something where the person, the heir, the beneficiary, doesn't have immediate access to it. So we want to set up some sort of creditor protection trust, and we're going to name a third party who has complete discretionary authority to distribute money. And what I mean by that, first, a third party. It's not the beneficiary. So again, we don't want to give your son, your daughter, your beneficiary immediate control of the money, because if they're able to just go into the bank and withdraw money from the trust account that you set up for them, that's not going to give them any creditor protection, because a creditor could potentially get a judgment to force them to withdraw money in order to pay off their debts. So we don't want to give them direct access. So we need to give a third party. It could be, could be a person, could be a company, a trust company or something like that, who they give money to your client, or excuse me, to your kid or to your beneficiary. So that's what we mean by third party. The second thing is discretionary, meaning that they get to choose when or when not to give money to the kid, right? So they get to decide, hey, we're going to give you $1,000 now. We're going to give you $2,000 now. But your son, your daughter, your beneficiary can't just go to the third party and say, hey, give me $10,000, because if they have that amount of control, if they're able to do that, then the creditor could then go to the third party and say, hey, this person owes me money, release the money to me. So that's why it's discretionary. They get to choose when they give money, because if they know that there's a debtor, and they know that if they give $100,000 to your kid, they know that the debtor's going to have immediate access to it. It's going to be able to get that money. So that's why it's discretionary. So that's something to think about if you're looking, if you're concerned about a loved one, if you're concerned. Again, it really depends on the amount, and it depends on the circumstances of your beneficiary. In most cases, this is probably going to be a child. You're afraid, hey, if they get into a lawsuit, or maybe they are involved in some things, that could get them involved in some sort of lawsuit or sort of judgments. Maybe you don't want to give all the money to them outright. Maybe you do want to set some sort of creditor protection trust so that potential judgments, potential creditors can't go after it. Something to think about when you're doing your estate plan. Just make sure, because you probably want to make sure that the money that you are leaving to your kids actually goes to them and not to any sort of creditors.